Harry's putting up a good fight, but he's on the losing side. And I hate to break this to you, Harry, but you're wasting everybody's time. That's your First Amendment right to do it, and I support you in that. But I just want you to be clear about how you've lost this. All right, so what you're unaware of is even a judge must have a legitimate reason or a legitimate government interest to give an order. There is. Estes v. Texas, the freedom granted to the press under the First Amendment must be subject to the maintenance of absolute fairness in the judicial process. Was this court even in session? Were any of the reasons a court has authority to restrict photography actually happening? Doesn't matter. Chandler v. Florida. They reviewed Florida's rules on filming in the Florida program. The Florida will allow limited photography. The court didn't have any issue with that. And U.S. federal rules of procedure do not allow or disallow photography. The U.S. federal rules of criminal procedure prohibit. The court must not permit the taking of photographs in a courtroom during judicial proceedings or the broadcasting of judicial proceedings from the courtroom. And the judicial conference, ad hoc committee on cameras in the courtroom, they don't allow, the judicial conference does not allow recording in courts. There is a pilot program in 3 districts in the Ninth Circuit, California Northern, Washington Western, and Guam, that do allow some photography in some courtrooms, but they don't allow photography or filming in the courthouses. This is the 5th Circuit. Cameras and recording devices are not permitted in the John Minor Wisdom United States Court of Appeals building without the court's permission. There's no time frame. It doesn't matter if court's in session or not. They're not allowed. Your argument is invalid. You need to rethink it or continue to be wrong. That is your right to do. Also, United States v. Grace, it's argued that the Supreme Court building and the grounds fit neatly within the description of non-public forum property. Although the property is publicly owned, it has not been traditionally held open for the use of the public for expressive activities. The government can limit your First Amendment activities. All they need is a rational government interest, and the solution, the prohibition, needs to be reasonably related to it. It's a very low bar. It's one that the government wins and the plaintiff loses. That's just your general rule of thumb. It is very hard to convince the government, like with Adderley v. Florida. Protesters on the front lawn of a jail. It doesn't matter. Their rational reason is they want to maintain order in the jail, and this is reasonably related to it. So you can't protest on the lawn of a jail. At least your First Amendment right won't trump any trespass order given by the sheriff of the jail. So yeah, I'm sorry. The great weight of jurisprudence is against you. You will have to literally change the Supreme Court's mind. You'll have to convince 4 out of 5 justices that everything they've done over forever has been wrong. And you're not going to do it, especially not with your abilities. Anyway, thanks for watching. Have a great day.